Hi, everybody. Welcome back to another episode of Tax Law Insiders. With me today, I guess I should introduce myself first, right? I'm Brian Seidensticker. I'm CEO of Tax Sale Resources. And with me today, I have with is Scott Walterbach. He's with Bessine Walterbach LLP, which is an attorney firm out of Missouri. And Scott's one of the few and the finest attorneys in this country that focus on tax sales, which is a niche within a niche. Anyway, Scott, we've chatted in the past. You gave us a great overview of how sales work in Missouri. Welcome back.
It's good to be here, and thank you for having me. I appreciate the opportunity.
And Scott, I guess we were kind of chatting before we hopped on this recording, but I think it'd be great if we focus a bit on I'll say lessons learned, things that case studies. You and I both kind of geek out on this stuff, but the things that most investors, new investors come in the space, don't really know, and being involved in those cases, and some of that case law that sets the statutes and how things need to operate in Missouri. I'd love to get your insight on what some of those, I'll say past cases or some of those situations you've found your clients in. I guess not really you, but your clients in, and just kind of educate us a bit on what the lesson learned was.
Yeah. First of all, that's not the first time somebody's made that mistake. I get people all the time that think that it's me investing in all these tax sales, and it's not. Unfortunately, I've never gotten into that, but I represent plenty of clients that do. And one of the biggest things that these cases come down to, and the biggest area that we have issues in, is noticing, sending notice of the right to redeem in a way that both complies with statute and with notions of constitutional due process. And so,
and that's with that, I don't mean to cut you off, but I think that's key for anybody that hasn't listened to Scott and I in the past or any other interviews done with attorneys. Is everyone leans on the state statutes, right, Scott? But there's really two things that you're trying to abide by. State statutes, like everyone knows, but there's this idea of due process, which is a federal level thing of things that are required in order to notify people or give them the opportunity to respond. And that's really what drives probably a lot of the confusion of what I should or shouldn't do. I just want to make sure the listeners understand that it when you're talking about what's required, and you're sifting through, if the investor's sifting through the statutes, they can't find why you're doing this. Well, that's exactly why. There's more to the story, as we all know.
Yeah, there's case law out there, and so we're following case law both from Missouri and just nationally on tax sales. Some of the most prominent cases on tax sales at the federal level are not from Missouri at all, so we're kind of following all that sort of thing. And so to think of the statute as not a ceiling but a floor, that's the biggest thing I try to drive home to investors. And some are savvy and sophisticated, and they pretty well go it alone on sending notices, and there's nothing wrong with that necessarily. Others rely on me completely to do their noticing for them, and so and then there's everything in between. They'll come to me with questions, and so it just depends on your level of sophistication. But that's part of what we do, not only taking it through a quiet title after the fact, but helping with notices along the way. And so I wanted to share one just kind of anecdote. I have plenty of cases going on right now, but I want to talk about one from, I think it was 2015 or 2016, because I feel like it highlights the issue that we're talking about here, which is sending out proper notices and following up on them correctly. This particular case had an absentee owner who frequently traveled abroad. And there are provisions under Missouri law about how you can send notice to people abroad. This case didn't necessarily involve that, because at the relevant times, this person actually was here in the States, but essentially the property was a rental property. He had lived in it for, I don't know, 10 years, and then for about 5 or 6 years or so, and I may be getting the facts somewhat wrong, but this is close enough to give you the gist of it. Hadn't lived there didn't receive mail there, and that kind of thing. Well, never updated the county, right? And so there wasn't really anything at the county to indicate anything other than that this person, John Doe, lived at 123 Main Street. And so that's, of course, what you would do initially is send notices to that address, and obviously what the language in your notice has to comply with the statute and notions of constitutional due process. And I cover that pretty extensively in the white paper that I did for tax sale resources. And so a lot of that's in there, but at any rate, sent the notices. Some of them came back, some of them did not. And so then the question becomes, okay, what else is there to do? Do a search. Client did a basic search, sent notice to another address that was found. Didn't know whether it was a good address or not. And that was kind of that. Go to apply for the deed. There's no redemption. Get your deed. Get it into quiet title litigation. In Missouri, that's kind of how we do it. We have a non-judicial foreclosure process, and then we confirm it with a judicial quiet title. And lo and behold, here comes the bank, and that has a mortgage on the property, and the trustee for the bank, and this individual owner himself. And what are they gonna attack? Well, under Missouri law, the statutes are fairly clear that there's a very limited number of things you can attack about a tax sale. But one of those is notice. And so most of these cases, that's where somebody who's defending a lawsuit against a tax sale purchaser, an investor, that's where they're going to hang their hat, is what is deficient about these notices, because the requirements are technical within the statute themselves, but then also they have this notion of reasonableness under constitutional due process. And so that, anybody can argue that what you did was not enough, or what you did was insufficient for any number of reasons, and you only get to learn that after the fact. And so this was a case where we, as the tax sale purchaser, learned that after the fact. They had all sorts of ideas about things we could have or should have done, that the tax sale purchaser should have done to effectuate actual notice. Of course, the constitutional standard is not actual notice, but it's notice calculated to get there under the circumstances. In this particular case, we went through the case, we did our written discovery, deposed the owner, had a pretty good feel for what the claims were, but there was just not much hope for settlement. Took it through the trial, go through all that process, and then about a month later, the court came out with a ruling that said, yeah, I don't think you did enough, and the tax sale is set aside. Luckily, this judge was good judge, fairly new, and read everything and did a good job, and provided the reimbursement to which my client was entitled. When your deed is set aside for a lack of notice in particular ways, there are ways that you complete it and prove it up so that your investment remains protected. In this particular case, though, let's dig into those facts about notice just a little bit more. In this case, the owner basically came forward and said, hey, had you looked in these specific places, you would have found that my current address is this other, in a neighboring suburb. Okay. Well, one of those places was what we call in Missouri CaseNet, which is very similar to public access, to court electronic records in the federal system. It's basically just the electronic records that kind of anybody has access to. You can search for cases. If you search for his name, you might have found this. The other problem was this was a foreign name, and it had several different kind of alternate spellings that we kind of sometimes Americanize people's foreign names, and so there's alternate spellings. Had we used one of those alternate spellings and looked in this particular, done a search for this particular database, we would have found it, right? Okay, well, that all sounds well and good, but to me it sounds like a big game of gotcha after the fact. But I'll just tell you, that's the way it is. They don't care. Judges don't seem to care what you did or how many notices you sent or how many cases you had to send notices on. They're just always going to look for, if a person's there, they're always going to look for a way that they can set aside the tax sale, and you're going to get your money back. You're just not going to end up with the property, and puts everybody back to status quo. And so that's kind of how it works out. So it just always kind of seems like a big game of gotcha. And that's what you have to be careful of, is when you're sending notice, you have to look at this from the perspective of somebody who doesn't know you, doesn't know what you know, doesn't have the resources that you have, and doesn't really care what you knew. All they're hearing is somebody's about to lose their property, and they're here screaming about why they shouldn't lose their property. And that can be very persuasive to judges. So your notices shouldn't be just, I'll just do the bare minimum to comply with the statute. We really try to go above and beyond to the ends of the earth. Any piece of information that we have or we can scrounge up, we'll use it to try to effectuate an actual notice to the recipient.
That's interesting. I mean, it's unique in the fact that maybe that particular individual and their name, was different enough to where that argument, I guess, kind of makes sense to me. But if it were John Smith, for example, right? I guess, yeah, you could dig up every John Smith in the world and send them notice, but that's also not economically feasible, right, across the board.
Right. And that's why you would probably look for some testimony from your client about their from the tax sale purchaser, talking about what is their process, how do they go about, where do they start, how do they go about finding new addresses, what happens if it comes back, what do they do?
Mhm.
And so you really have to bring the trier of fact, usually a judge, these are usually judge tried cases, not jury tried cases, and bring the judge into an understanding of what it's like to be in your shoes, to say, hey, this is what we've done, and this is why we've done it, this is why we couldn't do more, and help them along in that process. But it's an uphill battle all the way. I did have one case, a different case, even before this one, where the bank was arguing that we should have, it was a mortgage holder on the property in Missouri, we call them deed of trust, but essentially it's a mortgage holder, was arguing that we should have sent notice to a particular address. And we were able to well, actually, I take that back. Before we get to that point, they were arguing that the collector should have sent notice to a particular address before even the sale of the tax sale certificate itself.
Hmm.
And it's clear they weren't going to settle. And I actually brought the collector in, subpoenaed the collector, and had them take the stand and question them about what do they do? How do they do it? Is it practical to do anything more? And at the end of the day, long story short, the court believed the collector's testimony that they essentially did everything they could within reason, given the nature of their office, how many people they have dedicated to these things, how much time they have, and what kind of databases they have, and everything that they can do. And they basically said, look, I don't see a way we could have done anything more. And the court believed that. So it's possible to prevail on those things, but notice is the biggest thing that I think investors underestimate or get wrong.
Mm-hmm. And it's you hit on a good point. I want to reiterate that in the eyes of most, I'll say, judicial figures, the guys making the judges, whoever's making the decision on, is this house going to transfer hands, right? As soon as somebody jumps up and says, wait a minute, I don't think it should, most times that deciding entity, judge, whoever, is going to lean on the side of whoever is saying, hey, I want to keep my house. Because at the end of the day, and I actually agree with the sentiment, and some investors may not like me saying this, but the intent of tax sales is not to be a transfer of property. That's not the intent of it, right? It's the intent to ensure the payment of taxes. And if someone is not paying their taxes, then there's an enforcement to it, and that can be the transfer of the property. And so if there's any opportunity for the property to remain with whoever the previous owner was, and for the payment of those property taxes to continue, then most officials, judges, are going to side with the people that previously owned it, right? They're not going to side with the investor that wants to take ownership of that property. Now, I'm not saying what is ultimately right or wrong. I'm just, like you said, stated the reality of this industry and what judges typically take the side of. And that's just good to recognize that, because the other part of what you mentioned, I think, is good to revisit is you can try to make these bulletproof, right, and notice everybody in every single way, right, and have a solid case in every single time you go to foreclose. But the economical scale of doing that is just, it's unfeasible, right? You can't do that in every case. So you can be picky choosy and certain and say, I think this one might end up being contested, I'm going to do a little more, right, if that's what you want to do. Or you set the base of what you're going to do and just realize that there are going to be a few that slip out of the cracks, and hopefully end up with a judge that sees it the right way. At least you get reimbursed with whatever interest is owed to you, and I guess you're made whole. You may not get the home run out of that particular situation, but you're made whole on that investment. I just want to make sure those couple items weren't lost upon the listeners. Scott, sorry to interrupt.
Yeah, and I think Missouri is not unique in that regard. You'll probably never hear a judge or somebody say, hey, I'm going to bend over backwards to do anything I can to make the facts fit, setting aside this tax sale. I don't think they're going to do that, or they're going to say that. But at the same time, they're looking at it, and it's like, one is like an egregious harm, and that, to rights well rooted in our country and our Constitution, property rights. It's kind of what our country was founded upon. And on the other hand, while the investor's investment is still protected and they're going to get their money back plus interest, and not just interest from the redemption period up to the date of the collector's deed, it's interest up to the date of judgment. So they kind of look at it as, well, no harm, no foul. Yeah, you're not going to end up with a property. But like you said, if the goal of a tax sale was to transfer property, I think we'd have a heck of a lot shorter redemption periods, and we would make that happen much more quickly. But that's not really the goal. The goal is really to give the person every opportunity and some time and some breathing room to try to pay, and to give them ample notice so that they are very clear about what's happening to their property, and that they have a right to take action to redeem and all those sorts of things. But at the end of the day, we do recognize, whether anybody will say it or not, that a tax foreclosure is just sort of disfavored in the law, and they will find a way to set it aside if there's any shortcoming about it. Doesn't mean we don't try, but there's also a reasonableness limit to what you can do, especially if you've got a lot of properties. If you've got one or two, that's great. You might be able to do a little bit more because you've got a little bit more time and a little bit, probably just, you can pay a little bit more attention to the details of that specific thing. If a notice comes back, for example, here's another case I had where recently settled, where the notice to a particular bank came back with a forwarding address on there, and it's on this little yellow sticker on the front of the envelope. And if you're not looking real carefully, you may not catch it. And I don't think we caught it. And so we never sent a notice to this corrected forwarding address. Turns out it was like a successor bank, a bank that had bought, the bank. Banks are always, changing names and buying each other out and all sorts of things. So, but there was a new address on there. And had that been one of, two properties that this particular client had, well, they might have looked at that more carefully and said, hey, we need to pause, send out another notice to this new address. But instead, it was probably in a stack of 100 others just like it, and got missed. And that doesn't mean we're done. We still have ways that we pursued the case and got it resolved in a way that, we talk about settlements being something both sides can live with, not necessarily something both sides like, but both sides can live with, and we got it done, and it was to the mutual satisfaction of the parties. But that it's just one of those things. It's not just, and this is another thing that investors could be very aware of, which is not just what at the time you send out notices, but constitutional case law is pretty clear that it's not just at the time, but also what happens, what knowledge you come into after the fact. And Missouri law sort of provides for this about what triggers your obligation to send follow-up notices and what you have to do. We have plenty of times where I recommend that we'll find email addresses these days. We will post a notice on the property and get an affidavit, like a geolocated affidavit from a process server showing that they did it, and timestamp picture and all that kind of thing. And sometimes we've considered publishing or doing whatever else we can think of to do to effectuate actual notice. We want somebody to be able to look at it after the fact and say, look, they did everything they could. And even if we don't get to that point in litigation, we at least want to be able to make that argument in a persuasive way to our adversary so that maybe we can get it settled. Maybe, yeah, we still think we're not going to win, because at the end of the day, a tax foreclosure is disfavored, but we can give them a little bit of concern that, hey, there's a good chance the plaintiff wins here, so that can affect a possible settlement as well. So another way that an attorney could help you in this process.
Yes, like you said. And speaking of what lengths, some folks will go to, I guess this was an attorney, but it was a county official. I was talking to an investor, this is years ago, but the county official ended up going out on Facebook to try and reach this tax holder, property holder, basically to let them know, hey, you better take care of this because, the foreclosure's going through, and they ended up, actually being successful and not contacting them through Facebook. And that's kind of wild, but, in some regards, if that's the only way you can contact that person, and the county official was willing to do that, and again, put it back on the tax roll for that county, then it ended up being, I guess, the right solution in that situation. But like you said,
and in theory, a court's not going to necessarily require you to get that creative in effectuating notice. But at the same time, if there's evidence that you, like, let's say you are friends on Facebook or connected on LinkedIn and you didn't send a notice there, that's the kind of thing I'm talking about, where a court's going to say, well, why wouldn't you do that? If you had a real desire to effectuate actual notice, wouldn't you have done that? Like, let's say you want to go to dinner with somebody and plans change, and you've got to get them notice about, hey, I'm going to be a half hour late or whatever. Well, what would you do to get them a notice? Because you have a real desire to give them actual notice. You wouldn't just send a letter and go, well,
to the address on file at the treasurer probably wouldn't cut it in most cases, right?
Right. But that's, and I say that kind of flippantly, but I'm trying to illustrate the point that the court's going to look for, and the case law looks for, a real desire to effectuate actual notice. And those are kind of some of the things that you get into. What did you know? When did you know it? And then what did you do based on that knowledge?
Well, Scott, noticing and due process is a subject that I know comes up, like you said, not just in Missouri, in multiple states across the country. And this was great. I don't mean to, I know there's some other great topics, and I want to get to those, but we're going to save that for the next episode. So everybody listening, thanks for joining us. Tune in for another episode with Scott and I, and we'll talk about some more riveting topics. Thank you, Scott.
Yeah, thanks again for having me. It's been a pleasure.